She walks into court with special requests.
Sometimes I have to calm down. I'm on clonazepam medication for PTSD. When the conference was over, where AP Piper called me crazy, and I have post-traumatic stress disorder, and that definitely put me over the edge.
But the judge calmly shuts them down with a firm reality check.
Absolutely not. That's not an ADA protection. None of these things that you're talking about are ADA protection.
I was given.
You're requesting permission to take breaks as needed if panic or dissociative symptoms escalate. By nature of how we run the court, if there's a situation where you need to take a break, the court always grants breaks. So that's not something that needs to be requested or specially implemented. You request ability to pause a testimony briefly for grounding before answering questions. I don't know what that means. Grounding?
Yeah, it just means that sometimes I have to calm down. I'm on Klonopin medication for PTSD.
Okay, we don't rush you, so that you don't need to request that. So you can breathe or take your time whenever you are getting ready to answer a question.
Okay, Your Honor.
Okay, access to water at all times. Water is available. Did you bring water?
No, I did not.
Okay, so how do you think you're gonna have access to all times? If you think I'm gonna get you the water?
AP Pfizer says I would be having
that we can get you what we give the jury. It's a very small bottle of water, but you're more than welcome to bring all the water that you need. If your ADA requires you to have access to water, I would have imagined you would have brought water with you.
That was just part of a request in case, how long it takes.
We can get you water, but this is the size of the bottle. Okay. Permission to remain seated. You will be seated at all times during your testimony and under oath. It says questions to be asked one at a time. For the rules of evidence, they can't ask compound questions, so you don't need to make a request for that because they're not allowed to ask compound questions. If there was a compound question, there would be an objection probably by somebody. No yelling, raised voices, or hostile or intimidating tone directed at me. I don't know what you mean.
What I mean by that, Your Honor, is I felt that AP Pfeiffer had that type of tone with me at the last conference, and my son had to watch on YouTube when the conference was over, where AP Pfeiffer called me crazy, and I have post-traumatic stress disorder, and that definitely put me over the edge.
Your son had to watch, you said?
No, my son, he watched it. He watched because he knows your hearings are on YouTube, and he watched it. And then I didn't want to watch it because I've already been in, mental health crisis for a couple of months now. And I felt it was very unprofessional and against ADA law to
what does ADA law prohibits someone from yelling or raising their voice?
Calling someone crazy at that post-traumatic stress disorder.
I don't recall in my proceedings, Mr. Pfeiffer or anyone calling you crazy. That's number one. Number two, your request you're saying these are ADA requests. Asking for no yelling, raised voices, hostile or intimidating tone in a courtroom. First of all, some of it's relative, and what's intimidating to one person is not what's intimidating to another. I could be considered yelling right now, but I have to be assertive and I got to make sure my voice carries. And I also give instruction to anybody who testifies here to make sure their voice carries. And I've heard Mr. Pfeiffer give curative instructions to people that I want you to speak like you're talking to the person way over there. And so you're not going to be able to control either of their tone or the volume of anyone's voice when they're asking you a question. That's not an ADA requirement. It's not protected under ADA either, okay? You're asking for court intervention if question becomes adversarial, aggressive, or re-traumatizing. I don't know what is traumatizing to you or re-traumatizing. The court will not put themselves in a position where they have to figure out what might be traumatizing you. My job is to make sure that they follow the court rules. If there's questions that are argumentative, that's against the court rules, or if there's an objection, then that's when the court will intervene by the nature of a violation of the court rules. But when it comes to just asking questions that you don't like, you still have to answer them. You understand that? Prohibition on threats of criminal exposure. Absolutely not. You must be advised that you could face, some criminal exposure by some of the things, especially under your circumstances. And never have I seen anyone so adamant that they want to produce documents to the court directly and on the record that could put them at risk for criminal exposure. And that's what we have here, which is why you were advised that you should get an attorney.
Yeah, Your Honor, the clerk was the one that told me that I have to serve that, right? So.
The clerk cannot tell you that you need to serve anything. You probably call the clerk to find out how to get something to the judge.
Mm-hmm.
So that was on you. You can't blame it now on the clerk that you sent an affidavit admitting to perjury.
Okay, I don't believe I was admitting to perjury, but I understand.
Okay. You asked for acknowledgement on the record that I am a witness with PTSD. I don't know how you expect that to be acknowledged. You are only allowed to answer the questions that are asked. And so if that's asked of you, that's fine, to the extent that it may or may not be relevant to the information being brought forth, but the court won't be making any acknowledgements that on the record. And you're talking to me, and I already have been advised that you have PTSD. So
yeah,
I'm the only one.
PTSD and panic disorder.
Yeah, so that's fine. You let the court know. I'm the only one making a decision in this matter. This is not a jury trial, so you don't need to make an acknowledgement to anyone other than me, and I've already been advised. Okay. Assurance that accommodations will not be used to assess credibility. That's not an ADA protection none of these things that you're talking about are ADA protection.
I was given the list
from who?
Sorry.
Who gave you this list?
From one of the officials that I talked to.
What's the official's name?
I'm not sure. I don't have it with me right now.
Okay, these are not ADA requirements.
Okay.
These are some things that you might like, but in this particular situation, I'm the one that assesses credibility.
Okay.
No one else is assessing credibility, just me, okay?
Okay.
No negative inference drawn from emotional responses, pauses, or needs for breaks. I don't know what that means. If you're talking about how we determine credibility, there's a lot of mechanisms used to determine credibility. You won't be able to control that, okay?
I guess I should have rephrased that better. I just would ask Your Honor to take in consideration that I've been in an active mental health crisis for a few months now since my father passed away and everything else I'm dealing with.
I can imagine, and to the extent that you need, some pauses, or that you need a break, or that you're emotional, the court does not typically just make a negative inference on that, other than the fact that you are emotional.
Yes,